Hello and welcome to our ongoing educational webinar series. I'm Steve Branton, financial planner and advisor at Mosaic Financial Partners. Mosaic is a fee-only, independent financial planning and investment advisory firm with locations in San Francisco and Lafayette. Today we'll be focusing on the legal and tax issues of facing same-sex couples who are either planning to get married or have recently gotten married. So now I'd like to take a moment to introduce our guest. Alma Soongi Beck is an attorney specializing in estate, trust, and probate law. Alma also has a graduate law degree in taxation as well. She helps individuals, couples, and families with estate planning, creating trusts, navigating the often complicated probate process, and handling issues related to property ownership, especially as they relate to unmarried individuals and same-sex couples. Today, Alma will be giving an overview of the top estate planning issues facing same-sex couples as a result of the historic Supreme Court rulings from last summer, and looking at the pros and cons of marriage in general from a legal and financial perspective. So with that, I'd like to turn it over to you, Alma.
Thank you, Steve. So I'm going to be forwarding the slides as we go. As Steve mentioned, our practice has specialized for over a decade, about 13 plus years, in the area of unmarried couples and same-sex couples, which means that we've been tracking how the progress for domestic partners and same-sex married couples have affected people's legal rights, especially as it relates to their estate planning. So the focus of this talk is going to be about people's estate planning and those related issues. There's going to be a lot of overlap with the kind of financial advice that people get, and so let's just begin. So as with any legal presentation, we like to have our legal disclaimers. Please do not rely on anything in this presentation as legal advice, even if the hypotheticals that we talk about sound exactly like your situation. It is very important that you seek legal counsel specifically about your situation so that you can get case-by-case analysis of your situation. So let's begin. I'm going to start with what I think are the top 10 estate planning issues since the Windsor decision, and so we'll give a little background. It was almost a year ago, on June 26th of last year, that the United States Supreme Court struck down Section 3 of the Defense of Marriage Act, the Federal Defense of Marriage Act. And by doing so, it's pretty significant because it means that the Defense of Marriage Act had been on the books since 1996. And Section 3 is the section that said the federal government is prohibited from recognizing same-sex marriages or same-sex relationships. And by striking it down as unconstitutional, it actually means that Section 3 was always unconstitutional. So even though Section 3 was being enforced during that whole period until 2013, it is actually, now that it was deemed unconstitutional, anybody who got married in that period, including, like, for example, in other countries and other states other than California, would still have the rights federally that married couples have. So that's important, and it's going to come up in different parts of the conversation. So the focus of this talk today is mostly going to be on the pros and cons of marriage, and that's actually the top question that's been coming up for people, which is whether we should get married. Of course, there are people who already were married or people who got so excited after the Windsor decision that they got married. And so we're also going to be talking about what does it mean that your marriage is now recognized? Because even if you didn't do anything different and you'd been married for a number of years, the fact that it's now suddenly recognized federally changes a lot of things about your finances and your estate planning. Then we're going to talk about a bunch of other issues that arise from the issue of, it helps in the analysis of whether you should get married, but it also comes up for if you are married. So number 2, the issue that comes up is whether to update retirement and pension beneficiaries. The third one is whether we need to transmute our property. And transmute is a fancy legal word that we use in California to talk about changing something from community to separate, or separate to community. And community and separate property, we'll talk about what they are when we get there, but there's specific legal words that have to do with marital property rights. The fourth one is if we marry or are married, should we set up a trust now, and what should it include? We're getting a lot of questions from people, some of whom have trusts already, some of whom have not had trusts, that are talking about whether or not they should be setting up trusts and what kind of trust they should be. So the Windsor decision has radically changed how we look at living trust planning. So we'll talk about that as well. And the related question there is about whether we should have a joint trust. And the context for this one is that prior to the Windsor decision, because of the non-recognition for federal gift tax purposes, a lot of couples, even if they were married, had mostly separate trusts. Since 2010, we've actually started doing joint trusts for married couples and for domestic partners as it relates to their community property. And it's coming up more now where we have a lot of people coming in asking about doing a third trust or thinking about whether they should collapse their two trusts into one single joint trust. So we'll talk about that a little bit as well. Number 6, should we equalize our estate? There's a lot of situations where because of the same federal gift tax rules, people have been advised to keep their finances and their property separate for many years. Last night I did a version of this conversation at the San Francisco LGBT Center, and there was one couple there who'd been together for 46 years, but they'd only been married for maybe 3. And so it's interesting because had they been able to get married 46 years ago, their situation would be different and almost everything would be community property. But because they only were recently allowed to get married and had kept everything separate because of gift tax rules, a big question for them is, do we start adding everybody, the other one to title, to the properties and to the accounts? So we're going to talk about that. 7 is about Medicaid planning, or in California we call it Medi-Cal. And the question that comes up is, does marriage affect how we do Medi-Cal planning? And it does, so we're going to talk about that. 8, a lot of people have been asking what they should do with their domestic partnerships or civil unions. Should they terminate them? I'm going to give you the short answer, which is no. California does allow you to have both marriage and domestic partnership. Civil union is a term that has been used in other states. It was started in Vermont, which is basically at this point equivalent to state domestic partnership. It was just an alternative word people were using before we got marriage in those states. 9 is about what happens if we move. A lot of the rights that we're going to talk about apply only because we're in a state that recognizes same-sex marriage. So on the same day that Windsor was decided, Perry versus Hollingsworth was decided. And in California, that brought same-sex marriage back to California. But there are many states that still don't recognize marriage. And one thing that's important about the Windsor decision is that it specifically only is supposed to apply to those states that recognize marriage. The Supreme Court used a states' rights argument for why DOMA Section 3 was unconstitutional. It has always been in the realm of the states to decide how to define marriage and who can get married. And so what the question that comes up is, if you move to a state like Nevada or Oregon that is not currently recognizing marriage, I use that because they're right next door to California, how does it affect your marital rights? And so that's been bringing up very interesting questions for people who may consider moving. And then the last question is, for people who decide not to get married, especially if you're also not domestic partnered, what other planning and financial information should you keep in mind? Because a lot of people, after thinking about the pros and cons of marriage, are going to decide not to get married, or at least not to get married now. Or maybe they just don't want to get married for other reasons. And there's some very, very important planning questions that affect people who aren't married, especially in California. So my talks today are going to be limited to as it relates to California law. There might be some parallels to other states, but we are only licensed in California, and that's the basis of our analysis. Okay, so that's the overview. So we have a lot to do in the next 50 minutes. So let's start with the main question of the day, which is the pros and cons of marriage. There are over 1,000 federal rights and responsibilities, and to give you context for this, prior to the Windsor decision, we had basically 2 tiers of same-sex couples. One tier was people who were neither married nor domestic partners, and the second tier was either domestic partnered or married, or both. Because marriage was not recognized federally, the only rights you could get would be state-level marital rights. So domestic partners and married people who were same-sex couples were doing their taxes exactly the same as each other. Their property rights were basically the same with each other. What Windsor did last year was, for everybody who's married, it kicked up the people who were married another tier. So now all of a sudden the people who are married get federal rights as well. And there's quite a large number of federal rights, over 1,000. We're not going to talk about all 1,000 of them today. We're going to focus on the ones that are related to people's finances and estates. But the 3 tiers is an important framework for people, because now we have people who are married. Some of these people are also domestic partnered, and it doesn't really matter at some level with regard to the federal rights. Like I said, Windsor was very clear that its decision only applied to people who were married. It specifically said it does not apply to people who have other statuses that are like marriage, like domestic partnership, or civil unions. So that's the tier we're talking about. The middle tier is the people who are just domestic partnered, or also civil union, because California's domestic partner law actually says that it recognizes a similar domestic partnership anything that has substantially the same rights. So for example, if you're in a civil union in Vermont, you have the same rights as a married couple in Vermont. And so if you then move to California, you're recognized as basically having the same rights as domestic partners. So that's the second tier. And then the third tier is people who are neither.
You know, and Alma, just to interject, I mean, I think that on a high level, you know, as legal and financial professionals, I think that when, I mean, we're assuming that when clients come in and ask us this, should we get married, we're assuming that there's an emotional desire, there's maybe a social desire, there's a spiritual or religious desire that precedes the financial and legal review, because, at least in my opinion, if a couple doesn't have that, then looking at it solely from a legal and financial perspective doesn't make a lot of sense.
I totally agree with you, Steve. You should definitely not be deciding whether or not to get married solely based on the finances and the taxes. Right. But if our clients are going to come to us or to you asking whether they should get married, they're interested in the financial and tax perspective on it. Yeah. And so that's the perspective that I'm offering today. Yeah. And you should definitely decide based on all of your other values and your families and your situation. Right. One of the things that I did, there's actually an article that I refer to in this presentation at the end, and it's available on our website. And maybe, I don't know if you'll have it available on your website, but we'll figure out how to get you the link to it. But I wrote an article for one of the LGBT papers, and I wrote it before Windsor was decided, and it was published right after. And it was called "Why You Should Walk, Not Run to City Hall," because basically I wanted people to at least think about it, right? And yes, there's plenty of people, both opposite-sex couples and same-sex couples, who go rush and get married and don't think about it. But what I didn't want to have happen is have people at the end of the year be like, oh no, I didn't realize that that's how it would affect my taxes. Exactly. Or, oh no, I didn't realize that how it would affect the financial aid of my children. Right. And so people should at least be prepared. And that's part of what we do, is we help people get prepared. So I think so you know, so what I would say is, you know, if you've cleared the hurdle of there's a desire for an emotional commitment or, you know, other sort of non-financial, non-legal commitment, then, you know, talking to your tax professional, your legal professional, like a family law attorney or a state attorney, or your financial planner, to me it makes sense to make that the next step. And then you can kind of sort out the details. Yeah. But anyways, as Alma mentioned, we're going to be focusing on the legal and financial aspects today. I have a lot more to say about that, but we have a limited amount of time. Well, okay, let me just say one more thing. You know, one of the things about same-sex couples is because of the lack of rights for so many years, same-sex couples have these different stages of marriage in terms of some people before we could get married would be buying houses together or having a commitment ceremony. And then when we got domestic partnership, some would get domestic partnered, and then when we got marriage, some would get married, but some didn't. Right. And what I'm noticing is for the opposite sex couples that consult with us, it's a big bundle. So separating it is more difficult because it's like, you know, if you're going to have the wedding, you should get the license. Like it's just all part of it. Yeah. And so we're actually consulting with a lot of opposite sex couples about whether or not to get married, and we're doing the same analysis. Yeah. But culturally, it's they're coming at it from different perspectives. So we're finding same-sex couples more willing to think about separating it because we've had to for so many years.
And I think in many ways the issues facing the opposite-sex couples that we talk to that are getting married later in life, and the same-sex couples who weren't able to get married, you know, there's assets, sometimes there are kids involved, there's aging parents, there's homes that are individually owned. There's all these complicated situations. And so I think that hopefully this presentation will also be a benefit to those listening in that are not in a same-sex couple.
I would agree, and that the issues are very similar in terms of people have, if you're coming into marriage later in life, whether you're an opposite-sex couple or same-sex couple, with all of your assets, you have a lot of separate property, for instance. Yeah. And so a lot of the issues are similar. Yeah. Okay, here are the issues we're going to focus on. Now, when people come in to do a consultation with us about the pros and cons of marriage, we'll literally draw a line down the middle of a sheet and say, here's the pro side and here's the con side. So this is the PowerPoint version of it. But the things that are going to show up on the pro side are these: immigration, Social Security, Medicare, pension and retirement accounts, capital gains taxes, estate and gift taxes, veterans benefits, military spouse benefits, and there is more. So it will depend upon the actual situation of the couple, but these ones we'll almost always talk about. And the weight you give to them depends totally case by case. If you're not a veteran, then that's completely not relevant to you. For Social Security, immigration's an interesting one, and we're going to talk about that first. But for some people, immigration is the sole reason why they want to get married, because they're in a binational couple and they haven't been able to be together. Okay, so those are on the pro side, and here's what we put on the con side. We have 4: Medicaid or Medi-Cal, and that really actually depends on the situation, where you are in terms of your need for skilled nursing care, and which spouse or which person would potentially need the care. The second one is federal income tax, and this one can be substantial. It could be tens of thousands of dollars more in taxes, or it could be less in taxes. And again, it's very case by case. Financial aid for yourself, for your children, and public benefits such as food stamps that are federally based. All right, so let's start talking about, we're going to start going down the pro column. Immigration, we're not immigration attorneys, but we have done presentations with immigration attorneys after Windsor, and pretty much it's only a pro. If you're in a binational relationship and you've only, the person that's not a U.S. citizen or a U.S. resident has only been able to be here on a temporary visa, getting married now gives a huge amount of options in terms of fiancé visas and spousal green card petitions and all of that.
And the fiancé visa, that's if the person is overseas. So they can get access to the United States.
I'm not totally sure.
Yeah.
I think so. Yeah. I think it's because you're engaged, you can get them into the U.S., and you have to get married within a certain period of time.
I think it's 60 or 90 days.
I can't tell you because we don't practice in immigration. But yes, I think you got the basics of it right. And also, if you're already married, you can petition to people for certain visas for people and for green cards. Okay, so 2 is Social Security. So here's the deal with Social Security. Again, with Social Security, it's only on the pro side and not on the con side. So the way it could work, but it's not going to affect everybody. The benefit when you're both alive and of Social Security retirement age is if one person is earning more than 2 times Social Security of the other person. So for example, if I am earning $800, my spouse and I are both of Social Security retirement age, and I'm earning $800 and my spouse is earning $2,000, then I'm entitled to 1/2 of what the higher earning spouse is getting. So I would then be entitled to $1,000 and my spouse could still get $2,000. So that is very case by case because it really depends upon what Social Security benefits you'd be getting. And this is actually where talking with your financial advisor would be a huge difference, because if you're doing retirement plans for people, that's a really big part of the equation.
Sure.
And so, if my spouse would be getting $3,000 and I'd be getting $800, then it's almost a no-brainer in terms of the getting $1,500 instead of $800. So that's benefit number 1. And then the other benefit is the death benefit. So there's 2 death benefits. One is the $245 lump sum. And the other one, that's probably the more important one, is the ongoing death benefit. And so if you're the lower Social Security earner and the higher earner passes away, you're entitled to the full amount, 100% of what the deceased spouse would have been getting. Now, there's certain time restrictions. Like, for some of them, you have to be married for at least a year. And for certain death benefits, if you were married and then divorced, you have to be married for at least 10 years. So this is a good conversation to have with your financial advisor.
And the one thing I would say is something that we see with a lot of our clients is our clients are able to take advantage of the married ones of what we call the file and delay strategy. And we don't want to get into the details of that, but if a couple has longevity on their side, it can add several $100,000 in accumulated benefits over the course of a lifetime.
Right.
And it's not something that was previously, same-sex couples were previously eligible to. And I would also say about the death benefits, particularly if you have a stay-at-home spouse who he or she is not establishing their own work record. If they're a stay-at-home spouse and they're unmarried and they're raising children, then to me it doesn't make a lot of sense to stay unmarried in terms of the risk that that person is taking, not having their own Social Security benefit, not being able to apply for a surviving spousal benefit, and also if they're the non-biological parent, they wouldn't be able to receive the benefit available to a parent raising a child in the event of the untimely death of the workers.
Yes, in terms of the spousal death benefits.
No, what I'm talking about is the non-biological parent. There have been some in past case histories where if one of the spouses died, the higher wage earner, the other spouse, they're not married, has been taking care of the children.
Oh, they get benefits for the children,
right.
minor children.
They also get a benefit until age 16.
Right.
But if they're not married, then that person's not entitled to a benefit. So it creates additional financial stress on the family.
I would agree with that, Steve. And also, on the other side of it, and when we get to talking about financial aid for your children and about income taxes, the advantage of staying unmarried is that a lot of, especially for lesbian couples where they have more than one child, a lot of them have been able to file both as head of household, where when they get married, then they have to file as married. And so it depends.
Yeah.
How much more are they losing in taxes versus how much they gain from the Social Security benefits. And this is why it's so important to actually work with your financial advisor, because you can't really do the analysis of how they would weigh unless you actually do the analysis. So that's actually where for the income tax you need to talk to your tax person about that. Okay, so we'll talk about Medicare. This is another issue that's important to talk with your financial advisors about, but the way it works is that when you're 65, you're required to go on Medicare. Unless you're working and you still have health insurance through your work, or unless your spouse is working and you have health insurance through your spouse's work. So if you're not married, so you can see how it only applies to a certain cross-section of the population. If I'm not married and I hit 65 and I'm retired and my partner is working and I would otherwise get health benefits from my partner, it could be beneficial for me for us to get married so I can stay on my partner's health benefits. But that's a financial analysis, because going on Medicare is not bad, but it could be more expensive depending upon what the benefits are I'd be getting through my spouse's work. So it's very case by case. You actually have to look at the health benefits that you're getting from your partner's work.
And what you're talking about here, if you're an unmarried partner getting benefits, then there's a penalty for not enrolling in Part B. However, if you're married, you can delay the enrollment and you don't have to pay the penalty.
Right, exactly.
So
yeah. Okay, so that's that. The next one on the list is pension and retirement accounts. So I put this in all caps with an exclamation because when you get married, you're entitled to the spousal rollover. And so you can see the benefits of it, but I'll just talk about it for a minute, which is one of the huge benefits is you don't have to actually start taking money out of it till you hit 70 and a half if you're the surviving spouse. And the whole financial concept of being able to delay and let it grow tax-free can be a huge advantage. You can talk about it if you want.
Well, I mean, it's not something that people get married and think about, but when you work with clients that run the whole spectrum of retirement and distribution phase, it becomes very important when you start talking about required minimum distributions and delay. You can delay those until 70 and a half when your tax bracket is likely to be lower. Most people don't necessarily want to have to include extra income when they're in their, let's say, prime earning years. So this is a big concern of our clients, and it's an important consideration.
And on the other side, when you're not married, so if you are not married to your partner and then your partner passes away, if you're not a spouse, you actually have only 3 choices if you're named as the primary beneficiary. You can take it out as a lump sum and then take the big tax hit where it's just added on top of your income, and you lose all the future tax deferred, the tax free growth. You can stretch it over 5 years. That's called a 5-year stretch out. Or you can stretch it out over a longer period, either your remaining life expectancy or some shorter version if your deceased spouse was over 70 and a half. And the ability to take the lifetime stretch out is useful, but it still forces you to start taking distributions immediately. And so like if you're in your 40s, I mean, that's like 20 years that you have to start taking it out, or 30 years before you would otherwise have been required to. But again, it's hard to weigh the pros and cons until you actually do an analysis, mostly with your financial advisor. Okay, so that's about pension and retirement accounts. Now I want to talk about a side note, because there's all these couples who are already married. And one of the things that we're advising people who are already married is after the Windsor decision, it's a good opportunity to look at all of your pension and retirement account beneficiaries. This is actually a good thing to do every 3 to 5 years anyway. We recommend, even if you have a trust or an estate plan, that you review your documents with an attorney every 3 to 5 years, because a lot changes in terms of the laws, in terms of your situation. For same-sex couples, we almost recommend it even more, because for same-sex couples, there's a significant law change every single year for the last 13 years. So it's worth it to see if there's a change that's necessary. So the thing about this is, there are some very old school pensions and retirement accounts where they say that marriage cancels out the previous beneficiaries. Now, most of them are not like that. Most of them actually allow you to keep them even if you're married, but there are some ones that actually say that. And it is a small percentage of the ones out there, but as a general matter, I'm saying, why don't you just play it safe and just redo all the beneficiary designations and make sure they're current?
Yeah.
And you might be surprised at who might still be named as the beneficiary of your IRA, the one that you like opened 10 years ago.
And you know, on the other side of that, and I'm thinking about some people that I've spoken to, where you have a beneficiary of a retirement plan that's not your spouse. You know, now that you're married, and you have federal recognition, it's unlikely that the custodian or the holder of the account is going to honor that prior designation. So you'll have to get a new designation and have your spouse, if you want to continue to have that non-spousal beneficiary, actually they'll have to notarize that agreement.
Exactly. It's especially true in a state like California, where we're subject to community property, and so this might be a good chance to talk about what that is. Right. Community property is a marital property concept, and there's only 9 community property states in the whole country, and what it means is that anything you had prior to marriage, or in this case domestic partnership as well, is considered your separate property. So whoever earned it and whoever owned it, it's separate. As soon as you get married or domestic partnered in California, any future earnings are considered community, and the community is by definition 50-50. So if my partner is the only one working and she's earning $100,000 a year and I'm home with the kids, as soon as we get married or domestic partnered, every single paycheck, 50 of it is mine. So every year, 50,000 of it belongs to me, even if she takes it and puts it in her 401k or puts it in her own bank account. And so what gets confusing after marriage or domestic partnership financially is that the account in your name is no longer all yours. If you put any post-marital earnings in it, it's actually part separate yours and part community yours and your spouse's. And so the way it comes up in the retirement beneficiaries is that, so if I take a bunch of my post-marital earnings and I put it in my IRA, then, well, it's not all mine, and that's why we have to get spousal sign-off in front of a notary if I'm going to name someone other than my spouse. If I'm going to name my spouse for my $1 million IRA, it's a non-issue, because if she already owns half of it, she's getting the other half. But if I name my brother, and she's entitled to half, that's why the custodian might not honor it. And she actually legally might have a claim to part or half of it. So, okay, so it's a good idea. Redo the designations anyway. Make sure you get the spousal sign off, especially if you're naming someone other than your spouse for part or all of it. All right, next, capital gains. So this is another issue on the pro side of the list. Capital gains taxes, it applies only to capital assets, typically real property, stocks and bonds and brokerage accounts, and anything else that would trigger a capital gain, like sale of a business. So there are 2 huge advantages to being married for capital gains taxes. One has to do with your personal residence. So if I have a personal residence and I got it from before marriage, and let's say I bought it in San Francisco for $100,000 in the 80s, and now it's worth $2 million, which is probably how much that house would be worth now in San Francisco. That's an enormous gain. That's $1.9 million of gain if I sell it. Now, if I've lived in the house 2 out of the last 5 years, then when I sell it, I'm entitled to a $250,000 exemption. So instead of 1.9 million, it's 1 point whatever that minus 250 would be. The advantage if I'm married is even if the property is from prior to marriage and it's my separate property, by virtue of being married, I can claim $500,000 in personal residence exemption. So that is huge, especially if you have a property that's only in one name that was acquired before marriage. Mm-hmm. Okay? Yeah. And so the more realistic example would be, let's say I bought it at 100 and it's worth 500 now. So that would eliminate the capital gains tax if I am married. Okay, so that's advantage number one. It's only applicable in certain universe of cases. If you have a personal residence and it's only in your name. Now, most married couples that we're talking to, or people considering getting married, already have property together. And so when you already have property together, it actually doesn't matter if you're married or not married, because you each are entitled to $250 capital gains exemption. It depends actually, if you own it unequally, it could be significant if you're married to affect the capital gains taxes, but for most part it doesn't really affect it. The issue that can come up with co-owned property is actually what happens at death. So there's this concept in capital gains law that if you gift capital gains property to somebody, they retain the same capital gains basis. So let me just talk for a minute about what basis is. So let's say I buy the house for $100,000 and I spend $100,000 on improvements. My basis to that property is $200. If it's now worth $500 and I sell it, they take the current value and they subtract the basis, and that's the gain, and then I pay tax on the gain. So the gain would be $300 in that case. So in the case of basis, you want your basis to be as high as possible, because the higher your basis, the lower the difference is between the actual value and the basis. So that's the basic idea. If I could, maybe next time I do this, I'll put a happy face next to the word basis, because you want it to be as high as possible. So if I own a house, that same house, and I gift it to my brother, let's say, he retains my same $200,000 basis. But if I hold on to it until I pass away, and then I leave it to my brother in my trust or my will, then he gets what's the step up in the basis. So when I die owning the capital asset, there's an automatic step up in the basis to date of death value. So if it's worth $500 when I pass away, now his basis is $500 when I pass away. So that is a huge advantage. And that's actually why we suggest, we have a lot of parents that come in that say, I don't want to set up a trust, I just want to gift my house to my child. And we try to discourage that for many reasons, and one of them is this, which is your child will benefit way more if you just hold on to it till you pass away. Yeah. Now, when you co-own property together, the issue that comes up when you're not married is, let's say we bought that property together, my partner and I, and our basis is $200. So each of us get $100 in basis. So when I pass away, if we're not married, only the basis on my half gets stepped up. So she still has to deal with the gain on her half. But if we're married and it's community property, there's a step up on both halves. So you basically get the automatic step up you'd already get, and then you get a free step up on your half because it's community property. And that's simply a federal and state tax law, because they're trying to encourage marriages, because marriages, policy-wise, create more stable families and more stable government and stable societies.
And and that's a concept often it's hard for, sort of the layperson to understand. But imagine, the surviving spouse has a home that's appreciated, in the case that you mentioned, 1.9 million since the inception.
Right.
And she sells it the month after her spouse dies. There's no tax on that sale.
Right.
Now the problem is, of course, she'll lose the property valuation that she had, but we're going to get into that a little bit later on.
Talk about property taxes more? Yeah.
But zero tax. And when you see people that have owned homes 30 years plus and not to pay any tax on it, it's this double step up in basis as a result of marriage is
huge. It's like hundreds of thousands of dollars. But then again, it's case by case, right, in your analysis. So if you're weighing all these different pieces, Social Security and income taxes and capital gains taxes, you know, you want to think about what do you have that's a capital asset and how much has it appreciated.
Right.
If you have property that's depreciated since you bought it, this is kind of a non-issue in the current analysis, although it will become an issue when things increase. And it also affects your brokerage accounts. So this gets to the to-do list and the opportunities, which is that even if you have been married this whole time, the big question that's coming up is, should you do a transmutation agreement? What we're seeing is a lot of couples, like that couple that I met with last night, they've been together for 46 years. They have property from before they got married. They got it equally, it's joint tenancy. They were thinking that nothing needed to happen, but it's not community property. So if one of them dies, there's only a 1/2 step up in the basis. So in their case, one thing that we might recommend is transmute it either by deed or by agreement or by both. It depends on, we will sometimes do it only by deed, sometimes do it by deed and agreement, so that we know that when one of you passes away, there will definitely be a double step up.
So when you say by deed, you mean retitling a home from joint tenancy or individually owned to co-community property owned?
Exactly. If they already own it equally, like in joint tenancy, most cases we're okay with just a deed, because your joint tenancy is by definition already equal, and community property is also equal. So when you do a transfer where there's no beneficial change in the percentage and it goes from 50-50 to the same percentage, then we think a deed is sufficient because it's a writing that's signed by them showing their intent.
Okay.
However, when you have a change, like maybe one person's the only person that's been on title, maybe it's one of those situations where that's been the person who's had the better credit and the job, and they've kept their finances separate because they were concerned about gift taxes or whatnot. But now that they are married, it's time to add the other person to title. In that case, we'll recommend not only a deed, but also an agreement. And we actually send this person to separate counsel, the one who's giving up an interest, because there's also a concept when you do transmutation that the person giving up the interest should have separate counsel.
Okay.
So it's very case by case, but I don't want it to overgeneralize, because even in cases where we have joint tenancy, sometimes you have one person who is given way more to the property in terms of the down payment, and depending on the facts of the situation, we might still recommend an agreement in addition. Because we want the surviving spouse to be in a safer position for making.
So the takeaway is, if you own a home in San Francisco, the Bay Area, and you're married to your partner now, you want to add them to your title, and you want to retain this double step up in basis of death, you probably need to talk to an estate attorney before to just arbitrarily going in and
yes.
changing title.
You know, there's some documents I'm okay with people doing on their own, like their healthcare directives. I mean, I think you really should get legal counsel on it, but there's a lot of forms and it's fairly simple. You know, there's even some simple wills I'm okay with people doing on their own, but deeds, you should never, ever do your own deed, because the consequences of getting it wrong could be this permanent consequence that you have to live with for the rest of the period that you own the property. And it's just so serious, and it's so easy to just consult. I mean, we're talking about a pretty short consultation. For us to draft deeds doesn't take very long. Deeds and things like transmutation agreements, you have to get, so actually some of the agreements require that you actually get legal representation.
Because a piece of property has to go if you're retitling it into a trust, and you want it to retain the community property status, it has to go through one step before you retitle it into a trust, doesn't it?
Well, in some cases when people come in with joint tenancy property, we'll do a second deed to put it in community property and then put it in their trust. So for example, if a couple's been married for a few decades and they bought their property during their marriage, the presumption is that it's community. So the fact they bought it as joint tenants is actually contrary to the actual legal presumption, and we'll want to make sure there's a titled interest into community property. So we'll sometimes do a second deed. But with same-sex couples need to be very careful, because we have a lot of these cases where people have separate property, and it's legally separate property because they got it prior to when they got married.
Okay.
Okay. Yeah. Great. Okay, and then I want to say one thing about opportunities. This is true for any of the tax issues, whether it's capital gains, gift or estate taxes, or regular income taxes, which is, remember how DOMA Section 3 is unconstitutional all the way back to when it started? So if you're a married couple, or you're working with a married couple that has been married from before, and there was some capital gains event where they could only claim the 250, or they could only claim the single step up in basis, and they actually sold a property and had to deal with the capital gains. Had that marriage been recognized, they wouldn't have. They can go back and amend the tax return and claim that money back. It's kind of like Edie Windsor. I mean, her whole situation was that her spouse passed away. She had to pay $363,000 in estate taxes, and she sued for a refund.
But those protective claims are only back 3 years?
Typically, you can only open returns from the past 3 years, but there's an option that's on the slide, 9100 relief, which is under the Internal Revenue Code section 9100, where you can actually petition. You have to pay $14,000 to do it, but you can petition to actually have an earlier return open.
Okay.
And so it becomes this, pro-con analysis. Like, do you want to open up that return because then it opens it up for anything that was on the return?
Right.
And are you getting more than $14,000 back? Because if you're not, then it's not worth it.
And you also have to be married. Like, if you were a domestic partner,
correct.
5 years ago, then that doesn't help you. With
right. You have to be married because Windsor only affects.
So that was
marriage.
in 2000. If it's a California marriage, that's only really in that window in 2008.
Right? Not if it is a California marriage, yes, because the 2004 marriages in California were annulled, so those don't count. But there's a lot of California couples who were married someplace else before 2008. I have some clients who were married in the Netherlands in the 90s, and so all of a sudden they were like unmarried in California, and then all of a sudden they were considered married in 2008. Well, actually in 2009, because the 2008 court case didn't deal with pre-2008 marriages. So anyway, this is very case by case. This is why it's important to see legal counsel and to see your tax counsel about it. If you're thinking that this situation might apply where you want to open an earlier tax return, you should really see a tax attorney or a CPA who knows about how to handle this. Okay, so just because of time, I'm going to go a little faster with these other ones. Estate and gift tax. So estate and gift tax, this is the key issue that came up for Edie Windsor. As a reminder, the current estate and gift tax exemption is $5.34 million. So the very interesting thing about that is we might see a larger percentage of these clients because people who come to estate planners, who come to financial advisors, there might be a larger percentage of people in that category. But in the whole country, that only affects 0.3% of the population. The thing that's important is that the estate tax exemption changes. And it's changed a lot. It's changed almost every year in the last 12, 15 years. And so it could go down, it could go up, it could disappear. There's a lot of things that could happen. It's highly political. So if you're under the $5.34 million, please don't write off the gift or estate tax because you don't know, like you need to actually, it means that you need to actually pay attention to it more. And so this is also one of those cases where if you're in the situation where you would be subject to gift or estate tax, getting married, there's an unlimited marital deduction. And so you can give an unlimited amount at death or during your life to your spouse. All right, so the opportunities are, again, you could go back and amend tax returns. If you had to pay a gift tax or estate tax and you were married, then you can still open those returns, potentially. And this raises 3 issues in your estate planning. One of them is, well, how does this affect our trust planning? So one way it affects trust planning is if you're now eligible for the unlimited marital deduction, we actually do trust planning where you can leverage the unlimited marital deduction. And actually, if you have another generation or other family members you want to benefit, you can basically take whatever the deduction is and multiply it by 2 and protect that much from the estate tax from when you both go. A trust can do that. Without a trust, you can't do that. The way it typically works is, let's say my partner and I, we had $10 million of community property, and 5 was mine and 5 was my partner's. If we're married and I leave it all to my spouse, then that's $10 million that she has in her hands. So when she passes away, only 5.34 is exempt. So there's a huge estate tax when she passes away. Simply by having a joint revocable trust, we can eliminate the estate tax by having my share go into a trust for her benefit. So that's where we start getting into planning tools, but that is an important issue to raise with your estate planning attorney. We're seeing a lot of couples coming in for this, where they came in with trusts. We started putting marital language in our trusts in 2010, because 2010 is when the federal government started recognizing community property for tax purposes. But they were still not recognizing the marriage or the underlying domestic partnership. But because they were recognizing the community property, we knew that it was only a matter of time that we would get marriage rights. So we started actually putting marital language. It was conditional marital language. So it would say, if we have a marriage recognized, then it splits it in this way. If we don't, then it splits it in that way. So if you don't have marital language, you should actually talk to your estate planner about putting it in.
And the couples that, same-sex couples that we work with, particularly some that have, they basically set up estate plans, 5, 10, even longer years ago.
Right.
They're essentially not a marital trust. They're not, it's not a joint.
It's like two single people trusts.
Right.
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 Yeah.
Yeah.
So some people started adding the language as early as 2005 because there was a change in the domestic partner law then, but we weren't expecting them to change the marital law until later. So yes, if you haven't reviewed your documents since Windsor, then this would be a really good time to do it.
Exactly.
Okay, the next kind of related question is about joint trusts. A lot of people ask us about joint trusts because the advice before we had the unlimited marital deduction was, for the most part, keep your separate property separate. And so the danger at that time, this is prior to 2010, was if you put a bunch of stuff in a joint trust or in a joint account, you're making potentially inadvertent gifts that are subject to gift tax filing requirements and subject to gift taxes.
Mm-hmm.
And so I'll give you the example. If you commingle all your money and you're not married, and then if I put a bunch of money in a joint account and then my partner takes it out and puts it in her account because it has better interest rate, now that's a gift. If it's under 5 million, 5.34 million, I don't have to pay tax, but if it's over 14,000, I have to file a tax return.
Right.
So this is what we used to do before 2010, but if you're married now, we're not worried about that as much. So some people are coming in simply to simplify their documents. In the period of 2010 to 2013, we were doing a lot of 3 trusts for people so that people would keep their separate property separate and their community property together. And we were counseling people on what was community and separate property. It's difficult because you have to manage it differently, but we were doing it because we were concerned about the gift tax.
Mm-hmm.
A lot of those couples are coming back and being like, can we please just have one trust like all other married couples? So we're doing a lot more of those. So if you have 2 separate trusts or you have 3 trusts, that might be another thing to talk with your estate planner about, is whether or not you make it all one big trust. All right. The other question that is coming up around estate planning is whether we should equalize our estates. And so we've touched upon this before, but it's the question of, if, let's say, my partner's been the only one on title because she was the bigger income earner, does she now add me to title now that we're married? Because we can do it now free of gift taxes. Now, equalizing the estate is a very interesting question because when you equalize your estate and you add somebody to title, it's not, I'm adding you only if you're nice to me for the rest of our marriage, and you never cheat on me, and you never do anything bad, and then we never break up. It's you add them and now they're an owner. So it's an irrevocable gift. And so you want to make sure that people's frame understands that. I usually don't talk about, because of course nobody here on this webinar is that's never going to happen to. We're really just, but we want to talk about it that way, because if people have gotten used to being the only one on title, we actually send them to separate counsel.
Yeah.
Because if they often come in saying, oh, I want to add my spouse to title, and we're like, great, we just want to make sure that you're clear on the full ramifications of it.
Yeah.
So yes, take the opportunity if you want to, but don't jump to it. All right, so we're surprisingly almost done with the 10 that are on the list. 7 is about Medicaid planning. So now we're starting to go to the con side of the list. Everything we've talked about so far is on the pro side of the list. The con side of the list, Medi-Cal planning, in some cases, getting married is going to jeopardize more of your estate, because when you're married or domestic partner, that's important, because Medi-Cal is a state and federal right and benefit. When you're married or domestic partner, they count the income and the assets of both spouses. If I'm the partner with fewer assets, let's say I have $2,000. I can have $2,000 and still qualify for Medi-Cal, but if my partner has $1 million, now I can't qualify if we're married, but I can qualify if we're single. If you flip it around and I'm the one with $1 million and my partner has $2,000, it might actually be beneficial for us to get married, because I can still keep, or between the two of us, we can keep more, close to $117,000. So this is a very case-by-case scenario. You should talk to somebody who's a Medi-Cal planner. Our office does Medi-Cal planning, so we could also help you with this analysis. So some cases it helps you, in some cases it hurts you. In reality, with Medi-Cal planning, you can actually protect almost all of your assets if you plan for it in advance enough. So that's the key to that. All right. The next question on the con list is income taxes. So this one is actually a very major issue for a lot of people, and some people, their income taxes are going down when they get married, but most people, if they're two-income households, it's going up.
Yeah.
And this is true for hetero-married couples too.
Yeah. The marriage penalty.
The marriage penalty, exactly. And so it's just good for, a lot of people decide to get married anyway because of all the other pros and because of the social implications and because of their families and things like that. But you should at least know how much more taxes it's going to be so that you can plan for it.
Yeah.
The highest I've heard is $20,000 more. Most couples are somewhere between $2,000 and $10,000 more, but if you can find out by just talking to your tax person. And then if you don't have a tax person, just run TurboTax again as if you were married from last year and see how it would have changed it.
And the language is asking your tax preparer to run a pro forma of what it would look like if you were married. The other question I had is, you have, with your tax background, what happens if you get married, let's say on December 31st?
Okay, so I don't prepare income taxes, so I can tell you based on what the income tax preparers have told us. If you get married on the last day of the year, you file as married.
That's what I thought.
What I don't understand fully is what happens with all of the separate property income, but I think it's all if it's a joint return, you put it all together. If it's a separate, married filing separate return, you can still separate it.
Yeah. I think for the takeaway would be if you're planning to get married on New Year's Eve, talk to your tax preparer first, because I've actually heard of some instances where, they wanted to get married in the last couple of weeks of December and they ended up having a huge marriage penalty. They had just waited until January.
Right, it would save them a lot of money. The other analysis that's worth doing is that if you're neither married or domestic partnered, you should ask your tax person to also analyze if you're domestic partnered. Because what we're finding is in these three tiers from an income tax perspective, it's often this middle tier where people are getting the best tax results. Because if you have disparate incomes, domestic partnership still requires you to equalize, to equalize them, basically, and because community property is equal. So you don't get the marriage penalty, but you can still kind of come to the middle ground in terms of the tax bracket. So it's one of the many factors. Don't use it as your only factor, but it is an important one.
That's a good point. To add to, if you're really tax sensitive, is to ask your tax preparer to run you at domestic partners as well, because just from my experience, that was the most beneficial of the three,
for the most part.
Yeah,
right.
In some of the case studies that I looked at.
And there are some cases where domestic partners is the worst. And those are the cases where people are retired and they're getting a lot of separate property income from their retirement accounts. So it really just very much depends. Okay, so again, you can go back and amend tax returns if your taxes would have gone down if you were married. And then the last two cons I wanted to add here is financial aid and other federal benefits. So because we're running out of time, we're not going to talk about them much, but be very careful. If you have children in college or who are approaching college age, or one of you is in higher education and is needing financial aid, your spouse's income is going to be considered in that calculation. And so we actually have had some clients who've delayed getting married because their kids are in college or approaching college age.
Okay.
This is true for straight people too. All right, the last 3 points are about, these are pretty short. 8 is about what do we do with our domestic partnership or civil union. And in California, you shouldn't do anything with it. If you're already domestic partnered and you got married, you should keep both. There's no harm to doing it, and it doesn't really change your status. In order to get divorced from your domestic partnership or civil union, you actually have to get a divorce in divorce court. So why bother going through that expense and when it's completely not necessary?
And you can also, when you get married, you can also check a box on the form and it will dissolve the domestic partnership in
California?
Yeah.
It will do that?
Yeah, we got married, we did that.
Oh.
It just...
This is good to know. I didn't actually know that.
Yeah. Maybe this is recent in October.
Okay, but you didn't need to. And the other thing about it is we're generally recommending people not to dissolve their domestic partnership because there's a lot of states not recognizing the marriage, but that are recognizing the domestic partnership. And so in order to really get the broader range of rights, you may as well keep it. But it's too late. You can go re-register if you like. The slide is about, there's some states that had, like us, something similar to marriage, and then they got marriage. So some states who had civil unions and domestic partnerships, where you didn't have a choice.
Right.
And
Washington.
you were automatically considered married once you got married, unless you unregistered. But we didn't do that in California, and they didn't do it in Vermont.
Yeah.
All right, number 9 is if we move to a non-recognition state, the simple answer, please see legal counsel in that state. And in fact, if you're thinking about moving to a non-recognition state, seek legal counsel before you move. We're getting some interesting advice from people outside of California. Oregon is the example I'm thinking of, where they're telling people if you're eligible for Social Security, please apply for Social Security marriage benefits before you move. Because a lot of those states, they're not currently recognizing it. Social Security is not currently recognizing it.
Yeah, it's a place of domicile.
It's right. It's a place of domicile, but they think that might change over the next couple years. But anyway, we are a member of a national LGBT advisors network that does estate planning across the country. And if you're looking for referrals of people in other states, then let us know. We recently did this analysis for someone moving to Florida, and that's exactly the advice she gave us. Is it was better for him from a tax perspective to move to Florida. But from the marriage, he was married, and so from the marriage perspective, we had to think about the Social Security aspect. The last one is about if we decide not to get married or domestic partnered, please make sure you remember you don't get the unlimited marital deduction, so you still have to plan like you're single people from your estate planning and from your other financial planning. So you need to be careful of inadvertent gifts. So if you don't get either and you come to our office, we'll set up separate trusts for you. Number 2, property taxes. Property taxes is a major, major issue in California when you're not married and you're not domestic partnered. There is an exemption from property tax reassessment for domestic partners. We've had that since 2006, and for married couples since 2008. But if you're neither, there's a couple other very funky, very bizarre exemptions. One of them is from 2003. Carol Migden, when she was chair of the Board of Equalization, she actually passed that 462040, and she expanded it, but it's very complicated. So if you're in this situation, please see legal counsel about how to apply for it and whether it can apply to you. And the other one is an exemption, a co-tenancy exemption. I have a couple articles I wrote about both of these that are on my website, and they were also referred to in the presentation.
Before we move on, I mean, what would be, can we give an example of what would happen if 2 people were unmarried, and let's say the one that owns the home were to die and bequeath the property to the survivor in their will, but they were unmarried at the time of death?
Okay, so I'll use the same example we used earlier. Let's say my partner and I had been together since the 80s, and we bought our house in San Francisco for $100,000. So our property tax is based on $100,000. Prop 13 says the property tax is only allowed to go up 2% a year. So even though it's worth $2 million now, we might still be paying a property tax basis of like $400,000 or maybe $300,000. So we're paying this small amount of property tax. If we sold it for $2 million, the new person would pay maybe $24,000 in property tax or something like that. And we might be paying like maybe a few $100s in property tax. So if I pass away and we're not married and we didn't do any of these other property tax planning, my half could get reassessed. And then now my partner is stuck paying $15,000 a year. So only my half would get reassessed, but she has to pay fair market value property tax on that half. And this often happens, it penalizes couples that have been together a long time, whose property's gone up a lot, and usually after they're retired. That's when one person passes away. And so now my partner's on fixed income, and a lot of couples have had to sell their property because they can't afford to live in it. And it's incredibly traumatic and disruptive, aside from losing your partner. So this is extremely important, especially if you have appreciated property that you co-own. One last thing that's not on this list is you should really also do a property agreement if you are not married and not domestic partnered, so that you can be clear about what are the rights to reimbursement in case you sell the property. An agreement can save you tens of thousands of dollars in a court action.
And by the right to reimbursement, that means if you sell the property while you're both living in, maybe you're splitting up or something.
Yeah, maybe if you're splitting up, or maybe if you just sell it and you need to figure out what share goes to whom. But if you can agree on it in advance, you can spend maybe a few hours, like 3 to 6 hours, doing an agreement. But if you end up disagreeing about it because you're in a fight, then and then you want to sell the property or force it to sale, you can do that through court, through a partition action. But it's a very unfriendly process. It's very expensive. It usually costs $30,000 to $50,000 each to fully litigate something like that. So I like to call these agreements the agreement to protect your partner from yourself later when you get married, or if you do. Okay. All right, so it looks like we're a little bit over time. These are some questions that have come up that I think we touched upon some of them. Did you want us to make a comment about, we're going to stay on, if you want to jump off, it's okay. I think we're going to open it to questions and answers right now.
And I mean, some of the questions that were trickling over to me these were some of the principal subject areas. And, I think just quickly, when, we could talk a minute about when a couple should seriously consider a prenup agreement before they get married.
So, for the most part, prenups, in some cases it's the same advice I give to opposite-sex couples, which is if there's a substantial amount of separate property that you had before the marriage, or that was inherited by your own family, that would be cases where I would strongly consider a prenup agreement. The other thing would be having to do with because what a prenup does is it deals with your property before the marriage, but it also deals with your earnings after the marriage. So the other thing would be if you would rather have your income not be community property, so you can completely opt out of community property altogether. So those would be the reasons why you'd consider it. The important thing about prenups is you want to start them at least 6 months in advance, because there's no family attorney that will start a prenup prior to 6 months in advance of your wedding, because there's case law that says if you do the prenup too close to the date of your marriage, the pressure of the date itself could make it invalid.
Okay. And then with children.
Oh, can I say one more thing about prenups? For same-sex couples, there's a lot of same-sex couples who've done prenups prior to their domestic partnership because they wanted to opt out of community property because of the tax rules that made tax filing more complicated. So there's a lot more same-sex couples who have prenups or who may want to consider them, especially if they decide just to do domestic partnership and not marriage. Okay.
And how does marriage affect the benefits from a financial and legal perspective of children?
Well,
I mean, it's kind of a general topic area,
but there are things from the tax and financial perspective. There are things on both sides of the line. I used to be a board member of our family coalition, and that's a LGBT parents organization. And what they were finding in their membership is that marriage made the children and the families feel more stable. Now, I'm not sure it by itself makes it more stable, but there's, just in terms of if you think about your children and the questions they ask you, are we married? Why are they letting us get married? Like that. The interesting thing now that marriage is completely, legal in California, the question about why they aren't letting us get married is not coming up as much. And so then it raises the question of, well, just because we can get married, does it mean we should get married? And so the financial analysis part of it, we've talked about some of it, which is, well, FAFSA application, like financial aid application, it could hurt you. Your income taxes, it could hurt you because you can't file as head of household anymore. But it could help you in some other ways in terms of Social Security benefits, Medicare. It's basically the whole analysis that we did. And so this gets very interesting because there's often this principle I've heard from retirement planners and financial planners, which is you should prioritize your retirement plan, even though I know you really want to prioritize your children's education plan. But there's always other options for the children's education that aren't available for you if you're not actually doing your retirement plan. So it's a complicated topic, and that's why you have to be thinking about all the factors.
And one of the areas that I just want to bring up is, we see, we talk about this a lot, is if you plan to live in California, you're married, you have children, you're a domestic partner and you have children, and you're either both one is the biological and the other is the adoptive parent, or you've done a second parent or step parent adoption, then the rights are the same as for any heterosexual couple. The issue is when you move to what we call a non-registration state.
Or non-recognition.
Yeah, right. Non-recognition state. And there's actually some states that specifically prohibit same-sex couples from co-adopting a child.
Right.
Utah, Mississippi.
While there are states that prohibit that, when you have, this is part of why, So in this case, domestic partnership and marriage have the same level of rights, which is that when you're a domestic partner or married, you can do an easier process to adopt your domestic partner's child or your spouse's child. The interesting thing is when you're married or domestic partnered and one of you has a child, like gives birth to the child, for instance, the other one is actually presumed under California law to be the parent. Right. So you're technically adopting your own child, which is a little counterintuitive. But the council that have been actually doing these adoptions for lesbian couples in particular recommend it because of those states that don't recognize the adoption. But not the adoption. That don't recognize the presumed parentage. They have to recognize the adoption because parentage, they have to recognize it. There have been some states that have tried to say they refuse to recognize it, but those are not constitutional. So you need to be careful. You know, if you have family members if you're regularly traveling to states with your minor children that are non-recognition states, it might be worth it to seek counsel in those states to just make sure that there's what the issues would be so that you can plan for it.
Now, debt, obviously, this is something that a lot of people have asked about. You know, am I responsible for my fiance's debt? You know, and the question is before, the debt that they've incurred before marriage and also the debt that they incur after marriage.
Okay, so this is another case where domestic partnership and marriage are the same because debt is related to community property, which is a state right. And so the way it works is, so it's the same for domestic partners and spouses. Your community property is accessible to the creditors of either spouse, even from before you got married or registered. So it's only your community property. So if my partner and I were registered as domestic partners and we had no community property, then if I got into creditor trouble, they could not reach any of her separate property. But they could reach all of our community. And so that would actually relate to the prenup thing, which is when couples come in and one of them has concerns about creditor exposure, maybe because of their career or because of, you know, their student loans or whatnot, that would be a case where you might strongly consider doing a prenup because what you can do in a prenup is, like I said, you can say we're not going to have any community property. And if you say we have no community property, then you know that your spouse's or domestic partner's assets will not be accessible to your creditors.
Okay. You know, I hate to bring, I think we've already talked about student aid and the healthcare, a lot of the healthcare benefits, but what about divorce? You know, I think that's kind of the black box. No one wants to think about that when they get married, but I mean, now we would have to get divorced through California Superior Court or family court.
Right, exactly. You know, believe it or not, the ability of couples to get divorced in family court from a legal perspective is a huge blessing. Because before our domestic partners were the same as marriage, and before we got marriage, when same-sex couples would split up, we would end up in civil court fighting about our houses.
Right.
And that was ugly, and that's part of why we so strongly push property agreements for people who were neither registered or married, because the family court process, it's not fun going through divorce court.
It's more expensive too, right, than family court.
Civil court is way more expensive, and you can play way more awful games. What you can do in family court is, you know, family court knows that it's people breaking up their relationships, so it's designed in terms of its, like, you know, mediation processes, in terms of its attorney fee processes. You can do things like, you can, if you're the spouse that has fewer assets, you can petition for prospective attorney's fees from the wealthier spouse. You can't do that in civil court, and so it's just it's just a better process, and it retains more civility, even though you know that things can sometimes get ugly.
You know, and once again, the takeaway here would be if you are married in California but you're planning to move to a non-recognition state, you know, to consult legal counsel, you know, either before you leave or once you get there, because in the event, I mean, some of the states, Texas, for example, is not permitting same-sex couples to get divorced currently.
Yes, but California, even if you move to another state, retains jurisdiction to allow you to get a divorce here.
Right. So yeah, get married in California.
Well, get married in California. And yes, get married in California so that you can get divorced in California, I guess.
Well, I'm just thinking of, there's a couple of states that would, I mean, I've just heard of this, you know, we've seen, I've read case studies where a couple wanted to get divorced and they've had to move back to the state where they got married and spend 6 months, probably not together, but they've had to move back to, let's say, you know, the state where they got married.
Right.
and they had to establish residency before they were able to get divorced.
And that's part of why California did pass a
Yeah.
law that it retains jurisdiction over
Yeah.
that marriage or that domestic partnership
Yeah.
if you're in a state
Yeah.
that doesn't recognize it.
So I think we're about out of time. Do you want to click forward to your contact information?
Oh, okay. So here are the articles. They're actually on the presentation, and you can find them on my site. This is the one about why you should walk, not run to City Hall
Yes.
after DOMA is repealed. These are about property taxes. This one in July, there was a huge rule change around property taxes in October of last year, and this affects non-married, non-domestic partners. So I wrote an article beforehand, things you can do before they change it, and then I wrote one after that says things you should be careful of now that it's changed. It is extremely significant. If you're not married and not domestic partnered and you own property together, please read these articles. These are my associates. If you contact our office and you want a consultation, you will very likely be meeting with our associates because they handle the initial consultations. I'm not going to go through all of their full bios. This is David, this is Kim, and this is Nicole. You can read all about them. They're experienced, they know how to counsel with same-sex couples, and they're also experienced estate planning attorneys.
All right. Well, Alma, I want to thank you so much for coming in and sharing your expertise in this area with us. If you have any other further questions, feel free to shoot me an email at steve@mosaicfp.com. And as I mentioned earlier, we'll be posting the recording of this webinar in a few days on our website at www.mosaicfp.com/events. And you can also find out more about our upcoming webinars, and in particular to register for next month's Couples and Money webinar by visiting our website or following us on LinkedIn, Facebook, or Twitter. Thanks again for joining us, and goodbye for now.
Bye.